and shepherding the case through to asking.
Sorry, that was me. I'm since I'm doing this not in my courtroom, it needs to be live, and so I just went live. So you're all influencers now.
Yeah, fair enough. So it's pretty straightforward default, Your Honor. This was just a contract that exists between my client and the defendant. The amount at issue is based on the values of the contract and the fees. I think for seeking $20,000 plus in damages, $2,500 in fees is a reasonable amount. So with that, we submit to you.
Okay, Mr. Sinclair, I did review the file. It does appear that the service by registered mail is authorized under Georgia law in this circumstance, and that occurred on June, I think the 12th, based on the service date or the signing date for the registered mail, but it wasn't filed till June 22nd, but more than 45 days has passed since that time and no motion to open default has been made. I agree with you that the $2,500 you've requested in attorney's fees is not unreasonable. And so if you will submit your proposed order, I will take a look at it and confirm that it meets with all those requirements. One thing I would like for you to do, and it'll just help me if there's ever an issue where we have to go back to this order, is if you can include in your order that service was accomplished using the registered mail corporate service provisions for a non-registered entity. And it's only because, as you might imagine, when I first see something that's registered mail, that means I have to go backwards and look at like 4 other things to make sure that it was appropriate. So if you just put it in that order for me, if I need to go back and look, I'll be able to see it right there in that order.
Understood. Thank you.
Thank you. And if you'll just email that directly to Ms. Johnson, then we will get it on file for you.
We'll do so today. Thank you so much.
Thank you, Mr. Sinclair.
Okay, bye.
Okay, Broadwell Oaks Homeowners Association versus Ariane Holcomb. Do I have anyone here on that matter? Okay. Mr. Pham, the Fulton County Sheriff's matter, my review of that indicates that the excess funds are less than the amount that the sheriff is seeking in attorney's fees. Is that correct?
That's correct, Your Honor.
Okay. Go ahead, Mr. Pham.
We're asking for the entire amount of the excess funds to cover the attorney's fees.
Okay. And Mr. Whitley, you're here because Fulton County is still in there, and I guess it's still owed funds. Isn't that right?
That's correct, Your Honor.
Okay. Mr. Pham, I took a look at the proposed order that I think you submitted a proposed order or maybe filed one. I can't remember, but in any event, the sort of standard order that I like, you guys have gotten used to it now, I think. If you could please submit that by email to Ms. Johnson, authorizing the discharge of the sheriff and the payment of the excess funds as fees to the sheriff. And then if you'll make sure and include that because it disperses all of the funds in the record, that the matter is closed.
Will do, Your Honor.
Thank you, Mr. Pham. And if you'll just send that directly to Ms. Johnson, we will get it today and we'll get it on file for you.
I will. Thank you so much, Your Honor.
Thank you. Yes, Mr. Pham, Mr. Whitley, have a good day.
All right. Thank you.
Okay, and Ms. First, the Parks at Cedar Grove. If you could just sort of walk me through generally what your proposal is.
Yes, Your Honor. Thank you. This lawsuit was filed for past due homeowner association fees starting January of 2020. Assessments are $165 per quarter. The lawsuit was filed May 27th of this year. It was served personally June 14th. No answer has been filed. During the course of the last 2+ years, the affidavits presented to the court indicate that the owner's only paid $365 during the course of this time, for which he has been given credit, but it leaves a remaining balance as presented in our affidavits to the court, principal of $1,763.50, fines in the amount of $750, which for street parking violations, the provisions of the declaration specifically say that parking on the street is prohibited. And a copy of the violation letter was included with the complaint imposing the fines. The interest is $219.77. Attorney's fees, including the time spent for preparing and appearing this morning, total $2,108.24, which is $1,937.24 prior to today and $171 for today. An affidavit of attorney's fees, including our firm's billing statement showing the amounts incurred prior to appearing this morning, have been attached and filed with the court. These fees are reasonable and customary and necessary for the prosecution of this case. I've been practicing scarily almost 20 years in the community association industry, but even longer than that as an attorney. And we would certainly ask that you award our judgment as requested for a total of $4,841.51.
Okay, Ms. First, everything that you have outlined appears to be in order. I did take a look at the proposed order that you had filed in Odyssey. If you could do me a favor and have someone email my office to Ms. Johnson that order in Word format,
We will certainly do that.
we will get it filed for you.
Yes, Your Honor. Thank you very much.
Thank you, Ms. First.
That concludes my business. May I be excused?
Yes, thank you.
Thank you.
And before I move on to Mr. Taylor, there's a gentleman on my Zoom that's identified as, I'm sure I'm going to mispronounce this, Titana Moore. Sir, can you tell me which case you're here for?
I was on the parts of Cedar Grove. I'm Kevin Ridley. I'm sorry, I have it's the wrong name up there.
Okay. Well, I apologize, sir, because I did not see that your name. Was not aware that you were here. And Ms. First has already stepped off of the call. Do you understand the purpose of today?
Understood.
Okay. I would encourage you, sir, to reach out to Ms. First's office or to your HOA.
I've reached out to them several times. Sorry to interrupt.
No, I understand. And I know it's hard to get in touch with them, but my experience is that even with a judgment, they will work with you to arrange a payment plan or, whatever can be worked out. Okay.
May I add, because the house is currently for sale, I realized that, a lot of these fees, I went through some life-changing stuff and I realized that I needed to sell the house. And also, they've already placed a lien on the house. And I was told by my HOA, once it's sold, they will get a lump sum before I even see any funds. And I was fine with that.
Yeah, I can't give you legal advice, but I can tell you that generally speaking, it's been my experience that when there are HOA fees that are at issue, that those are satisfied out of the proceeds of any loan. So if there were extra proceeds when you sell the house over and above like any mortgage that you owe, then yes, typically they would get paid out of those funds before you would get paid out of those funds. But again, I can't give you legal advice or tell you, or certainly you don't want my financial advice. So, okay. So good luck to you, Mr. Ridley. Thank you. And you're free to get off the call now.
Thank you.
Thank you. Mr. Taylor, American Express versus Pius.
Yes, Your Honor.
If you'll just walk me through, I noticed that yours did not have any attorney's fees.
No attorney's fees, Your Honor.
Okay, but I saw the proposed order and I do have it on file. If you'll just sort of briefly walk me through it, that would be helpful.
Yeah, it's a principal amount of $11,407.23. We did submit an affidavit of my client with that. We're asking for plus the court costs. We have $320.91 for a total balance of $11,816.15.
Okay.
I mean 51. I'm sorry.
Well, I would have seen it on the paper, so it's fine. And in any event, Mr. Taylor, as I said, I did take a look at the proposed order that you had submitted, and everything does appear to be appropriate. And so we will go ahead and get that order on file for you. I do have it, and we will get it probably filed today.
Thank you, Your Honor. We're going to get the certification, the corrected version of that. We'll get that taken care of too.
Okay, excellent. Thank
I
you, Mr. Taylor.
apologize for that.
No, don't worry about it. It's all the paperwork, all those T's and I's that have to be crossed and dotted. So.
Well, thank you very much, Your Honor. May I be excused?
Yes, thank you, Mr. Taylor. Have a good day.
You too.
Okay, Ms. Minto Constantine. Ms. Minto Constantine, are you here? Can you hear me? If you can, now would be the time for you to turn your camera on and unmute. Okay, I see you're unmuted. Can you hear me?
I'm hearing you. I don't know if you hearing me.
I
I'm
am hearing you. Yes, ma'am.
Okay.
Okay,
Yeah.
excellent. Okay, so we are here today in the matter of Oakley Township Homeowners Association versus Joan Minto Constantine and Nikisha Minto. Mr. Joseph, if you could please walk me through the basic issues associated with the filing service and default, and then we'll talk about the other issues associated with the damages that are being sought.
Yes, Your Honor. Good morning. Richard Joseph for the plaintiff, Oakley Township. On March 22, we filed our complaint for unpaid homeowners associations assessments and associated charges in the principal amount of $2,655 plus interest at 10% per annum. The homeowners association charges date back to 2018. For 2018, 19, 20, and 21, the annual assessment was $525. For 2022, the annual assessment is $555. Our complaint also seeks attorney's fees for this present action, costs and attorney's fees for costs for the present action, and costs and attorney's fees to collect a judgment that we are collecting against Minto Constantine in a previous matter. Ms. Minto Constantine was served on June 5. Originally, we named another defendant. I think it was Nikisha Constantine. That defendant's been dismissed. We were not able to serve that defendant.
I see.
Ms. Minto Constantine failed to file an answer, and as the court has observed, she is in default in this matter. We filed a motion for default judgment seeking damages of principal amount, just as in the complaint, $2,655, interest at 10% per year of $702, court costs amount of $222. Our litigation expenses in the present action total $1,143, and reasonable attorney's fees for this case in the amount of $1,845. We're also seeking our expenses and fees for the collection of the previous judgment that was obtained in Fulton County State Court in 2017. There's a copy of the FIFA attached to my attorney's fee affidavit, and those collection expenses total $615 for a total of $7,182. We might have inadvertently submitted an order which stated that the attorney's fees for count 2 were $1,143. The minute I saw the order, I knew that was, I saw that discrepancy, but actually the true amount is $615. So I'll be sure, if the court grants the judgment, to send it in the correct amount. But as I stated, I have an affidavit attached to the motion for default judgment certifying the default. It contains our billing records, and in my affidavit, and I state now in my place, that the fees and expenses, both in this case and for collection of the judgment in 2017 case, are reasonable for the work performed. I've been a practicing attorney since 1982. I've done creditors work exclusively since 1991. And I have been with the firm of Lezegan Johansson since 2016. I further state in my place that these fees are commensurate with those charged in the Atlanta market and are customary for the work done in cases of this type. And again, my billing records are attached to the affidavit. So to reiterate, the judgment we're requesting is principal $2,655, interest at 10% per year at $702, court costs for $222, our litigation expenses in the instant matter for $1,143, attorney's fees in this case for $1,845, and $615 pursuant to count 2 for costs and fees incurred in collecting the previous judgment in 2017, and that totals $7,182.
Okay, thank you. Okay, so Ms. Minto Constantine, I just want to, so just to make sure you understand, the presentation that Mr. Joseph has just made is that you were served with this lawsuit regarding the HOA fees that you're required to pay as part of, the ownership of your property. And that you were served with that back in June of 2022. The paperwork that you would have been served with would have advised you that you had 30 days to file a response, and that no response was filed. And so the request from Oakley Township Homeowners Association is for the entry of a default judgment because an answer was not filed, indicating a response to the lawsuit. What would you like to let the court know regarding this matter?
They did not file me personally, no paperwork at all. I did not get no paperwork from no one, never hand me no paperwork at all, Your Honor. That's not true. And I was living in Florida all this time, and last year I come home because I took sick with corona, and I resigned my job in Atlanta, in Florida, because from I buy the home, my kids and mom live there, and I live in Florida. When I took sick and come home, then I started working last year, August, in Fulton County School. I reached out to the association to let them know how much I can pay, and they did not want that amount that I can pay. Then they send the garnish to Fulton County School, which I start to work this August here, make 1 year, and I start to work there. And they've been taking the association, been getting the pay from the school.
So
I
ma'am, forgive me. Let me interrupt you for a second. So I want to explain one thing to you. So the garnishments you're talking about that are coming out of your pay currently with Fulton County, those are different from this. I know it probably seems the same to you because it's the homeowners association, but my understanding is that the homeowners association previously obtained a judgment from you that has nothing to do with today's judgment. And that would be what they are taking out of your currently garnishing out of your paycheck. This is a different issue. This is a new lawsuit saying that during a certain period of time more recently, that you have not paid your HOA fees, I think through March. And in terms of service, the representation that's been made by the homeowners association is that they provided the legal papers to your son, who is approximately 32 years old, residing at that address. And Georgia law says that placing it in the hands of a responsible person is sufficient service to put the person you're trying to reach on notice that the lawsuit exists. Do you understand the two different things?
No, that you're explaining it to me, I understand it, but my son don't even live there, and I did not get any paperwork from my son.
Well,
I live there now with my mom. None of my kids them live there. Maybe my son may be passing there at the time where they maybe give it to him. I did not get any paperwork from them at all. And I did not get any paperwork from my
Sorry
son.
to interrupt. When did you said you've been back for about a year now?
Yes.
When did you move back to the house?
I moved back to the house April 21.
Okay.
In April 21, I come back April 21 and was back and forth to the hospital, like say sometime in Miami until I resign in June 21 from my workplace.
Okay. But so you were living in Atlanta at that address in June of 2022, like 2-3 months ago. Is that right, ma'am?
Yes.
Okay. Okay. Ma'am, so here's my issue. I have an affidavit from the sheriff's department that says that they placed this legal paperwork in the hands of a person who identified themselves to them as B. Minto, as your son, age 32 years. And so I don't have any reason to question that if the sheriff's department says they gave the documents, that they did give the documents. And it appears that you resided at that address at the time that that occurred, which would make the service that was made sufficient. I'm sorry that you did not receive the paperwork, but the service is, it does appear to be legally sufficient. And an answer was required to be filed no later than 30 days after the answer, or excuse me, after the complaint. And so it does appear to me that that Ms. Minto Constantine is in default, and that a default judgment would be appropriate here. Ms. Minto Constantine, I am very sorry. I know this can be frustrating for people that don't quite understand these procedures, but I will recommend to you that Mr. Joseph and or his client, I mean, just because I'm going to enter an order or a judgment on their behalf, typically despite your prior experience, typically they are willing to work with you to see if there is a monthly amount that they can negotiate with you to pay to bring you up to current. And so that's my best suggestion for you. But at the end of the day, I do think that the complaint was served in June, and that no answer has been filed. More than 45 days has passed, and therefore Ms. Minto Constantine is in default. And so I am going to enter the default judgment that was requested by Oakley Township Homeowners Association in the amount of $7,182. Anything else, Mr. Joseph?
Thank you, Your Honor. I'll submit the order with the correct figures to Ms. Johnson as soon as we're off the call.
Thank you. Anything else, Ms. Minto Constantine?
I can't pay no more than $100 a month.
Well, I'm not the right person to talk with about negotiating that, but I do encourage you to talk with Oakley Township and or Mr. Joseph about what amounts you might be able to pay, that you could work together with them to get that taken care of. Okay, ma'am?
Okay, Mr. Joseph, in which way can I get in touch with you so that I can make that arrangement?
Well, there's no guarantee that a proposal will be accepted, but you can call my office at 404-35.
Hold on. Sir. 404.
Correct. 350.
350.
1192.
Thank you.
Please tell the receptionist you live in Oakley Township and she'll connect you with the proper person.
Okay,
Thank you. Good luck
Thank
to you.
you.
Have a good day.
Thank you,
Thank
Your
you.
Honor.